This court further opined that though doctors are not immune from legal proceedings in the event of their negligence in discharging their professional duties, in the interest of the society, it is necessary to protect doctors from frivolous and unjust prosecution. It was further pointed out the need to frame either statutory rules or administrative instructions incorporating guidelines for prosecuting doctors on charges of criminal negligence. This court, therefore, ordered that until such guidelines are laid down, the following procedure is required to be followed. Parachange. We propose to lay down certain guidelines for the future which should govern the prosecution of doctors for offences of which criminal rashness or criminal negligence is an ingredient. A private complaint may not be entertained unless the complainant has produced prima facie evidence before the court in the form of a credible opinion given by another competent doctor to support the charge of rashness or negligence on the part of the accused doctor. The investigating officer should, before proceeding against the doctor accused of rash or negligent act or omission, obtain an independent and competent medical opinion, preferably from a doctor in government service qualified in that branch of medical practice who can normally be expected to give an impartial and unbiased opinion applying the test to the facts collected in the investigation. A doctor accused of rashness or negligence may not be arrested in a routine manner simply because a charge has been levelled against him. Unless his arrest is necessary for furthering the investigation or for collecting evidence, or unless the investigating officer feels satisfied that the doctor proceeded against would not make himself available to face the prosecution unless arrested, the arrest may be withheld. Parachange. Messrs. Tropical Agro Systems Private Limited, the respondent number 1 in the civil appeal arising out of SLP number 14692 of 1990, on the other hand, entrusted certain packets of pesticides ensured with respondent number 2, Messrs. Oriental Insurance Company Limited, to the appellant at its subordinate office at Madras for being carried to New Delhi. According to the respondents, the goods aforesaid were delivered at New Delhi in a damaged condition, resulting in loss to respondent number 1, and a suit was instituted for recovery of the loss to sustained by the respondents in the court of the 3rd Assistant Judge, City Civil Court, Madras. In both the suits, the appellant inter alia took the plea in its defense that in the contract entered into between them, the parties had agreed that jurisdiction to decide any dispute between them would be only with the courts at Bombay, and consequently the courts in Madras, where the two suits referred to above had been instituted, had no jurisdiction. This plea was repelled in both the suits by the trial court. The order of the trial court in each of the two suits was challenged by the appellant before the High Court of Judicature at Madras under Section 115 of the Code of Civil Procedure, within bracket hereinafter referred to as the Code, bracket close. This challenge having failed in each of the civil revisions, the appellant has preferred these civil appeals. The question which arises in both these civil appeals, therefore, is as to whether, in view of the relevant clause in the contract between the parties, the courts at Bombay alone had jurisdiction. Stop.